and thank everyone for joining today. We're happy to have you, and we're happy to be here as well. Elizabeth and I are with Preferred Legal Plan, and we have been providing our legal plan as an employee benefit to the university for the last 15 years. We've been one of your UFSelect benefits. So everything we talk about today, and I'm going to give it off to Liz here in a second, but everything we talk about today is going to be stuff that we can help you with through the legal plan. So Liz is going to cover a lot of the substantive information about which documents are important to protect yourselves and your loved ones from an estate planning standpoint. But what I want to encourage everyone, as Patricia mentioned, please post your questions in the Q&A box. Please post as many as you like, because Liz will speak for about 15 minutes on the substantive information, and then we like to open it up to Q&A for the rest of the time. Uh, we've seen when we do these that most of the information, most of the good information comes out through the Q&A. So please don't hesitate to post all your questions, and that's how we're going to handle it. We'll try to get to as many, of course, as we can. On that note, I'll pass it off to Liz to start the discussion on which documents you need to protect yourselves and your loved ones.
Good afternoon, everyone. Thank you so much for having us. We're happy to be here again. I see a lot of familiar names and faces. So thank you for taking the time out of your busy days and your lunch hours to be here with us to listen to this seminar about how to protect yourself and your loved ones. I always like to tell people that these are the type of documents that people don't really want to think about. They don't want to do. It scares them. They think it requires a lot of information, a lot of time. That's where I come in and where Preferred Legal comes in to assist. We're here to help you, to guide you, to make this process as seamless and as easy as possible for you, your family, and your loved ones. The time to do these documents is now. I get calls, unfortunately, later stage when people can't sign, they're not of sound mind, they're in a hospital situation. And getting these documents done now as opposed to at that time does make things a lot easier, happens a lot smoother. It makes it easier on you, and it also makes my job as a lawyer much easier as well. So if you have the legal plan or if you're interested in doing these documents, please don't hesitate to reach out. I will go ahead and put my contact information in the chat after my presentation so that you can reach out and get these documents done for you and your family. These allow you, as I mentioned, to arrange your affairs, express your wishes, tell us how you would want to be buried, cremated, what dress you want to wear at the funeral, how you have wishes for your children, who you want to elect as the guardians. That's where these documents come in, and that's why they are important, so that you and only you alone can get your affairs in order and express your specific wishes. It also allows you to appoint someone to make the decisions if you're not around or unable to make the decisions based upon incapacitation or dementia, whether you're under anesthesia. That's where all of these documents will come into play. And I'll walk you through them. You'll see there the bullet points that I'll be addressing and what I'm going to cover during this presentation. The first thing I always like to tell people is beneficiaries. During open enrollment or during any time you receive any type of information from your bank, from any of your financial institutions, it is super, super, super important to make sure that your beneficiaries are updated. Many times people go through a divorce, someone passes, and you forget to update those beneficiaries. Those are key. So after this seminar, please take the time to go through those additional accounts, update those beneficiaries, and make sure that they do include those individuals that you wish to inherit or receive those benefits from those accounts. The first document I want to talk about is a last will and testament. This type of document is created during your lifetime. It allows you to express your wishes clearly in those documents and direct how you want your assets to pass and whom you want to have guardianship over your minors, if you have minor children, at the time of your passing. This is all modifiable. You can change these documents at any time. So I always advise is do these documents for now. You can always change if your situation changes as well. The next document is the revocable trust. I get asked about this one all the time. This is also a document that's created during your lifetime that is very similar to the last will and testament, and whose main purpose is to avoid probate. This also can be modified during your lifetime and is a document that you can put those wishes in as well. One of the other documents that I always advise is the Ladybird or life estate deed. This is a document that is specific to Florida. Some other states do have this available, but this is also a document that's created during your lifetime and allows you to list a beneficiary on your real estate. It passes to those individuals upon your passing, and it avoids probate. Almost happens with the snap of a finger. They would go down to the property appraisers, submit the death certificates, and the real estate would be able to transfer, avoiding probate. This also allows you to have full, complete control and use of the property during your lifetime. The other documents that are important during your lifetime are the durable powers of attorneys, the health care surrogates, and the living wills. And I'll go through all of those. These are all modifiable. These are documents that you should have for yourself, for elderly parents, for any adult children, if you want to be their decision maker. And the main one that I get questions on is that durable power of attorney, which you give authorization to both a primary and an alternate person on a broad range of legal, financial decisions. So there on that, you can always modify who you elect, but it remains in effect even upon incapacitation. The healthcare surrogate is exactly what it sounds like. It's the document that authorizes, again, both a primary and an alternate person to become your substitute decision maker upon incapacitation, and gives them legal authority to speak to doctors, manage your care, make any type of medical decision for you. This one comes into play for any cognitive impairment. It can be Alzheimer's, dementia, mental illness, schizophrenia, any intellectual and developmental disabilities, or like I mentioned earlier, you're unconscious through anesthesia or during a surgery. If you're doing a heart surgery, they find something wrong with your lungs. Who would be able to make that decision along with the doctor to proceed with that specific procedure? The last one I'll speak about is one of the last ones is the living will document. People get confused with the living will and the last will and testament all the time. So I'll go through that quickly. The way I like to describe the living will is a document where you officially state your wishes not to be kept alive through artificial means, similar to the pull the plug document. So if you're in a vegetative state or in a similar condition, this document allows you to go ahead and list somebody who, along with the doctor, can decide to pull you off of those machines. The other document is the DNR. Again, this purpose of this document is to let medical professionals know that you do not want simple CPR measures or do not want to be resuscitated if you suddenly go into cardiac arrest or even stop breathing. So again, people confuse it all the time with the living will, but they're completely different documents. And usually this DNR is something that I recommend towards the end of life at an extremely advanced age, just because, as we know, CPR and those type of measures can prolong your life and can give you many more years to live. So these are the type of documents that I recommend. I went through it quickly just to give you an overview and give you enough time for Brian to answer any additional questions. Please, please, please reach out. Please don't hesitate to ask any questions that you might have. We can go through all of this again in the question and answer section of the Zoom. So please put those in there. And then just so you're all aware, when you call me, it's just a simple conversation. What your situation is, family situation, whether you own real estate. So don't think that you'll be intimidated by that conversation. Please reach out. And like Brian did mention, the wills are something that is covered for you under the plan. There's no charge. And those additional documents are at a huge, huge discount through the legal plan. Okay. If you go into the question and answer box, I see a few of you have already put some questions in there. I will turn it over to Brian, who will go through those and answer everything accordingly. Thank you.
Thanks, Liz. Yeah, I'm in the Q&A box, so please keep typing your questions in there as they come up, as you think of anything. And I have a variety of questions here, some about the legal plan in general and some about our specific topic today. But let me start at the top. Constance asks, I signed up for the legal plan years ago, but haven't used it yet. How do I go about starting to use it? So this is good for anybody that has the plan or is going to pick up the plan. It's very easy to use. Make a note of these two pieces of information. Our toll-free number, which is how we typically want you to start any issue, any question with us. Just pick up the phone and call, and we're available 24/7 at 1-888-577-3476. Again, 1-888-577-3476. And then our general email that you can feel free to email us anytime is going to be info, I-N-F-O, info at preferredlegal.com. And I'm going to spell that. So info, I-N-F-O at PREFERREDLEGAL.com. So please don't hesitate to reach out in either of those fashions, and we can start assisting you with whatever you need. Shelley asks, are there any requirements for people interested in accessing the legal support, talking about our legal plan? Is it free? Where can I obtain more information on what might be available? I'm going to mention some of the aspects of our legal plan benefit as we get towards the end of our deal today. But it is a voluntary benefit that you could pick up through the university. It is $6.44 bi-weekly. Comes out to $13.95 monthly. So it is a paid benefit, but that's what we are at Preferred Legal. We're a membership organization. So when you join, you become a member, and then you have access to all of us and everything that we've been talking about. We're also going to share a flyer towards the end that'll give you a lot of the information about the Preferred Legal. Let's see. Anonymous asks, can beneficiaries be changed anytime or only during open enrollment? You should be able to change your beneficiaries every single day of the week if you want. That is not something limited to open enrollment. You could check with HR and just see if they have any kind of issue, but typically you can change those anytime, as well as on your outside accounts, IRAs, annuities, whatever you might have outside the scope of employment. All that stuff can be changed anytime you want. And we love using beneficiaries because of the flexibility of it, because it allows the asset to go direct, as Liz mentioned. Love the beneficiary designation feature. So yes, take advantage of that. And the best way is to be organized, make a list of every single asset you have. And if it's something that can be designated like an account, like a life insurance, retirement, annuity, what have you, stay organized so you know what you have and how you have it designated. And again, any asset you designate, that's how that asset is going to go, regardless of what your will says or your trust or anything else. The beneficiary takes precedence over anything else. And again, we like that, but be aware of that. Shelley asks, what options are available for designating minors as beneficiaries? This is a great question, Shelley. So designating minors as beneficiaries is sort of a no-no. We don't like that because God forbid if it comes to pass and the minor is going to receive assets, now somebody's got to set up a guardianship formally in the courts to house this money, to watch over it till the minor becomes an adult and all this. There's two options that we sort of prefer to that. One is if you're doing what we call a simple will, and in your simple will, you're still going to name your guardians of your minors, not a guardianship formally through the courts, but your guardians within your will that the court will recognize as, having custody, legal decision-making, etc. over the person. So you're going to still name your guardians in your simple will. And in that case, what you could do is then designate the account to the guardian, not to the minor, but to the guardian. Now, there is a little leap of faith here that we're trusting our guardian to take that money and use it for the child, of course. And if you're naming a brother, a sister, a loved one that we trust implicitly as the guardian, then we don't have much issue with that. But the better way, and the way we would recommend doing it, is a little more formal. And that is where, and this is important, for anybody with minors, instead of doing a simple will, and in our simple will, we do have protection to age 21. If a minor gets assets, the assets will be held by the guardian till the minor reaches 21. But if you take your life insurance, your retirement, your money in the bank, you throw everything in a big pile and you say, oh gosh, this is a few $100,000, this is $1 million, this is a lot of money that if I pass, I don't even want my 21-year-old to get several $100,000 and maybe go down to the Hard Rock and do something stupid and blow it. So to protect against that, we suggest and encourage creating what we call our complex wills. Within our complex wills, we're creating what we call trusts for your children, for the minors. Now, I'm using the same word trust, but this is a totally different concept from the revocable living trust that we're going to talk about a little more here with other questions. No, this is totally different. This is what we call trust for your children created under your will. So they're referred to as what we call testamentary trusts because they only come into being after you're gone. They don't exist right now, and they may never exist and should never exist because you're going to live a long and happy life, and your kids are going to be way older when you pass. So none of this will come into play. It's pure contingency planning, but it's good planning because if something happens, God forbid, and you pass, and the kids are younger, again, we don't want all that money going their way. So what the Trust for Children says is the money is there if the child needs it for any reason, for health reasons, for support, to do an extracurricular activity. They need new clothes. They want to get a car. It's time for college. We got to pay for college. Anything it can be used for, but that's at the discretion of your trustee, the person you're picking to manage these monies for the children. And again, brother, sister, loved one, somebody. And then we say at certain ages, we're going to allow the child to take out X amount and let the child sink or swim. And so what we do here, there's no magic to this, but we do a third at 25, a second third at 30, and the balance at age 35. So if the 25-year-old blows it, there's still two more in there. And hopefully by the time the kid is 35, it's like, hey, sink or swim, kid, at that point. But everything is adjustable. Everything you're doing is updatable at any time. So if, your kid hits 21 and you say, oh my God, this kid is the most responsible 21-year-old I've ever seen. I don't have any worries if something happens. Then we can scrap all that and simplify and move on to a different sort of strategy. Or the opposite. This 21-year-old doesn't have a clue. Oh my God, I got to up those ages to 35, 40, 45, or 50. And it goes both ways. So it's all, it's all changeable at any time based on circumstances changing. But again, if you have minors and you have a lot of assets, including life insurance, consider that complex will package with the Trust for Children. Excellent plan. Constance asks, I live with someone. Can they use my preferred legal plan? So back to the legal plan benefit. Yes, the legal plan for the one price is available to you, your spouse or domestic partner, your dependents, and anyone that lives in your household. If it's an elderly parent, if it's a significant other, if it's an older child, you can't get rid of them, we're going to cover them under the legal plan. Anonymous asks, I have elderly parents who are finally ready to get a will. However, English is not their first language. Would you be able to work with them? Who would you suggest for translators? The answer is yes, absolutely. We do habla inglés or habla español and parle Creole. So Haitian, Hispanic, we've got that in-house. If it's a different language, then I would maybe ask you to help when we talk to parents to translate or what have you. But I'm not too worried about that. But your question is a good one because we always, or oftentimes are doing estate planning through our legal plan for a member's parents. So all of you out there that have parents here in Florida, we can help them get their affairs in order. And obviously, they're maybe even more important than getting your affairs in order because they're at that later stage of life. Anonymous asks, is selecting the executor of the will in any of the documents? So yes, all of these appointees, nominations, what have you, are going to be mentioned. Whether you do a will, whether you do a trust, you're going to have everybody mentioned. And when you do your power of attorney and your healthcare docs, you're going to have your decision maker, primary and backup mentioned in there. So absolutely, these legal documents will incorporate everything that you need. Marie asks, if you have a revocable living trust, do you also need a ladybird deed? Great question. So this is when you get to a stage of life when your children are grown or you don't have children, but no more minors. Now we turn the discussion to, okay, we're not worried now about the kids getting it or what have you. How can we now arrange things so it'll be easiest on the children, i.e., they don't have to go through probate and can avoid the lawyers, the money of probate, the time, the months and months it takes, and the creditors that you have to deal with. A whole ball of wax is probate. It's not a nightmare in Florida, but there's a lot involved. So we say, let's try to avoid that for the kids or for your loved ones so that when the time comes, they'll be like, oh my God, this is so easy. We don't have to do anything. They set this up for us in such a nice way, blah, blah, blah. That's what we're talking about. So how do you avoid probate? There's a couple ways. One is with a revocable living trust. What is a revocable living trust? It's a legal document, just like a will, that says what your wishes are after you're gone. But then what you do is you retitle all of your assets, your property, your accounts, everything into the name of your trust. And when you pass, your loved ones just have to administer your trust, not your estate, through probate. And administering your trust is a few legal steps. You got to get a tax ID number. You got to file a tax return for the trust. You got to do a new deed to remove the property out of the trust and put it to the beneficiaries. So some legal steps, but nothing akin to a probate. So that is the living trust. And of course, probably everybody here has heard of trust. Oh my God, trust. We need a trust. You should have a trust. You don't have a trust. Oh my God, you need a trust. For years now, this stuff about trusts has been out there. But unfortunately, there's a lot of misnomers about trusts and what they do for people. People think, let me do a trust, put all my assets in it, and nobody can sue me. Wrong, incorrect. A trust does not provide any creditor protection whatsoever. The only thing a trust does is avoid probate, and only if you set it up the right way, meaning you've placed all of your assets into the name of your trust. The other problem I see with trust is people come to me and Liz, and they have trust they did years ago with an attorney on the street or what have you. And so I say, oh, let's see the deed to your property. Let's see your accounts. And of course, 99 times out of 100, not everything is put into the trust. If you do a trust and you pass away and you've left one account outside of the trust or one piece of real estate outside of the trust, now there has to be a probate and you've lost the whole advantage of why you did it in the first place. So as you might be able to tell, I'm not the biggest fan of doing trust packages for younger families. The alternative that we prefer greatly is the ladybird deed option. What's a ladybird deed? A ladybird deed is right on the face of a new deed. Instead of deeding the property into your trust, right on the face of the deed, we list your beneficiaries, if you want to call it that, what we call the remainder people, which are your children, your adult children, your other loved ones, what have you. They go right on the face of the deed. But you, the maker of it, retains all the control for the rest of your life. You can do whatever you want with this property, and you don't need the remainder people's permission. You have 100% of the control. If you're a married couple and you do it, and one of you passes, the survivor of the two of you continues with all the control. You can do whatever you want at any time. You can undo it, redo it, give it to someone else, mortgage it, rent it, whatever the heck you want. But otherwise, the ladybird deed is set that upon the second death or the death of the life tenant, it goes to those remainder people, to your children or whomever, like that. Snap of the fingers. They don't got to get a tax ID number. They got to do a tax return, do a new deed, like that. Amazing. The ladybird deed. It only exists in a handful of states, as Liz mentioned, but Florida is one of them. So left and right, we do ladybird deeds under the plan. We love it. It gives you so much flexibility. Again, you can change it anytime you want. You don't lose your homestead exemption. I mean, it has all the positives and none of the negatives. It is amazing. Now, if you ladybird your property, now you've set your property up to go direct. What about your accounts, your annuities, your insurance, your retirement? All you do is beneficiary each of those assets. And you've already done that on your life insurance, your retirement. You've got your beneficiaries. Even go down to the bank, your regular checking account with a few $100 in it, you can have a beneficiary to. They just call it at the banks POD, payable on death, or TOD, transfer on death. Same thing as a beneficiary. POD those bank accounts. Very important. The last thing I'll mention on this question, then I'll move along, is the banks. The banks, we think banks are our friends. We love the banks. No, the banks are not our friends when it comes to this end of life stuff. In fact, they work against us. Don't get me started on the banks. I hate these banks, what they put people through with this end of life stuff. It's ridiculous. So don't give them a chance. POD, those bank accounts, which means when you pass, the bank cannot freeze it, cannot hold it. They have to give it to your loved one. And they love to freeze and hold your bank account, your money. So don't let them do it. That's my last 2 cents there. All right, let's move along. For co-owners of a home, Alan asks, i.e. spouses, does ladybird deed only apply if you both die? So yes, that's what I just kind of covered there. If you're spouses, you're doing the ladybird. If one of you passes, the other spouse still has all the control, can do whatever they want, and it only goes to the next generation or to the next people on the second death. So that is correct. Gurjeet asks, what is the benefits of a living trust over the last wills? And that would be very easy. It's called avoiding probate. So again, if you're a younger couple with minors, we're not concerned with avoiding probate at this time, because even if you did a whole trust package, set everything up and did everything right, and you avoided probate, there still has to be a court process to deal with your minors, the guardianship and all that. So avoiding probate is not the concern when you're a young family with minors. What is the concern is protecting those minors with the complex will that I mentioned off the bat, with the trust for children and that whole deal. But the difference with the trust versus the will is an avoiding probate thing. So again, once the family gets older and the kids are adults, then we turn our strategy to how do we avoid probate. And that can either be with the trust or with ladybird deed and beneficiary. Stephanie asks, what is the difference between the living will and the DNR? Great question, because so many people confuse it. People call us and say, I need that DNR. And we're like, no, you don't. In fact, that's not even a document that an attorney provides. That's something you get from your doctor. But let's be very, very clear. and this is not a fun topic, but we'll talk about it. What is a living will? A living will is your statement that you do not want to be sustained artificially on the machines, which we know can breathe for you and do all these things for you. When your brain is gone, you're in a vegetative state, but they got you hooked up and they're keeping you alive. You don't want that. You want someone to pull the plug. Most people know that expression. That's the living will, advanced directive, whatever you want to call it. That's the pull the plug document. Everybody should have a pull the plug document, in my opinion, but people have their own opinions, and that's a personal choice. And this all came about, if anybody remembers here in Florida, Terry Schiavo from many years ago, who was hooked up on the machines, was gone, vegetative. Her husband said she wants the plug pulled. Her parents said, no, she never wants the plug pulled. And she did not have anything in writing. So the governor, Jeb Bush, got involved. The courts got involved. And it was a whole to-do. Eventually, they pulled the plug. Okay, just FYI. And that sort of kick-started all those years ago why now we want everyone to put it in writing, what your wishes are as far as that goes. That's the living will. The DNR is, if I go into cardiac arrest, if my heart stops, do not resuscitate me. No CPR. You don't want that. You only want that when you're, on the 18th hole, I guess. When you're in your 90s, you can get a DNR. But for now, if your heart stops, as we know, you could be gone for 10 minutes and they can bring you back and all those wonderful things that they can do. So I hope that was clear, DNR versus living will. Amy asks, if one of your healthcare surrogates passes away, does it need to be updated? Great question. So we usually and typically and always do a backup when we do these docs. So you have your primary choice and then your backup choice. If your primary choice passes, you still have your backup. So in that case, you don't have to update. We've already addressed it. But if your backup person or both people, or for that matter, anybody that you've named in some capacity, even as a beneficiary, if they predecease you, that is a trigger for you to update, of course. And I'll just sort of end that with this. With the ladybird deed, back to that ladybird deed, that is the only reason you would ever update a ladybird deed, unless your wishes changed. But otherwise, it's only if one of those remainder folks passes away before you, then you have to update. But look, that's usually the trigger. If someone passes, if circumstances change, you want to take a fresh look at everything. Anonymous asks, do I need a will for real estate if I have not paid off the mortgage? So I am not legally the owner of the house. Let me educate you on two things here. You are the owner of the house the moment you bought it. The moment you went through closing, you own it. Real estate is not like a car. When you're financing your vehicle, as we know, you don't get the title till you pay it off. Totally different from your house. When you close at the closing, you get the deed. That is your legal title to the real estate. Then what you have is a mortgage. You have a loan that is secured by the property. And what does that mean? It means if you don't pay that loan, your lender can foreclose and take the property to pay off that loan. It's a security interest. But it doesn't mean you don't own the property. You own it. And here is something very important. Remember what I said earlier about the banks, how much we love the banks. Your mortgage company, what's their only job? What's the only thing they care about? On the first of the month, they get their money. That's all they care about. They're never going to say anything to you about anything as long as they get their money. The moment they don't get their money, then they're going to come after you and stuff. But as long as they get their check every month, they're fine. And title and mortgage run separately on real estate. And what do we care about as the attorneys? What do we care about? Only the title, your deed. We can do whatever we want with your deed. We can put it in a trust. We can ladybird it. We can do this, that, and the other. And the mortgage company does not need to be involved at all and should not. Now, if you call your mortgage company and say, hey, I did a special deed on my property. Can I send it to you? What do you think's going to happen? They're going to get all worked up. You don't need that. Leave the mortgage company totally out of all of this and just keep paying your mortgage and you're fine. Anonymous asks, how do you set aside money and specify someone to take care of your pets in your will? So we love our dog and cat owners. We're dog and cat owners ourselves. So yes, you can, well, let me start by saying this. You can do and say whatever the heck you want in your will or whatever documents we're doing. You can express your wishes to the nth degree. You could, I mean, we've seen it all. You know, people leave 50 grand into a trust for their pets, you know, on and on, you know, so you could be as detailed, as specific, whatever the heck you want in your will. But that is something that we would put in there, that you leave your pets to this person and you leave them a pecuniary amount of money for the purpose of caring for those pets. You could leave your whole estate for your pets, whatever you want. And again, we got you covered with the pets. We love all that. Anonymous asks, is the ladybird deed limited to only properties physically located in Florida? How does it work for Florida residents with properties in multiple states? Excellent question. Yes, it's only in Florida, but there is another handful of states out there like Michigan, North Carolina, a couple others. So if your other property happens to be in a state where they also have the ladybird, then we could ladybird it there, no big deal. And remember, the ladybird is a deed on the property, so it goes with the property specifically. So even if the other state doesn't have it, you could still ladybird your Florida properties, and those would be set to go accordingly. The other option is to do the living trust. And you could do it in a number of ways. You could do the ladybird on the Florida properties and do a trust just for your out-of-state property. Or you could do a trust and throw everything into it. But you could do a trust and throw out-of-state properties into it, and that's how you would arrange those to avoid probate. So it just depends on what state those other properties are in, and we can help you look into that accordingly. All right, moving right along. I co-own my deceased parents' house with my siblings. Will preferred legal help us, all three of us, to do ladybird deeds? Absolutely. And this is a good question and an important point. You do not want to just go on to the deed with your parents or with whomever, you know, just like a quitclaim deed where they just add you to the title. It's not smart for tax purposes. You want to receive it upon death because then you get a stepped up tax basis that wipes out all the capital gain that might be in that property. Could be a huge tax savings. So ladybird deed or trust, not just putting you on the title now. Do I need a lawyer to set a will, mostly to specify legal guardian for my daughter who is a minor, or can I do it through an online service such as Trust and Will? Great question. You know, here's how I like to say it. You can write your will on a napkin as long as it's signed by you and witnessed by two people. That's it. That's the only legal requirement for a will. Signed by you, witnessed by two people. So you can write it on a napkin and it would be valid. But generally speaking, with all these documents, any of these documents is only as good as the legal form that it's on, right? So we want you to have state-specific forms because all this stuff is state by state. It's all based on state law. And sometimes those online services are more little generic forms that we don't love. So that's all. You know, again, it's only as good as the form it's on. So we want you to have the best forms. And coincidentally with us at Preferred Legal, I don't even think our members realize it, but we're delivering the top of the top forms on all the stuff we're doing. So very important. Candy asks, how old do beneficiaries have to be? So again, we just don't want a minor listed as beneficiary, but 18 is no longer a minor. So, but again, just know whoever you're naming, they're going to get that asset directly and it's going to be theirs to do whatever they want with it. So that's where we get back to that discussion of the complex wills with trust for children to kind of protect them from getting stuff at a younger age. But yeah, once the child's an adult, you can name them as beneficiary. Thomasina asks, does one need a last will and testament and a revocable living trust? Yes, when you do a revocable living trust, you'll get a will that comes with it, and that will is known as a pour over will. A pour over will, because all the will says is if I pass and I forgot to put something in my trust, now it has to go through my will. I just wanted to pour over into my trust, so everything would ultimately go under the terms of your trust, but you still get that pour over will with it. And the next question is the identical question, so I'm moving along to Adrienne asks, is creating a ladybird deed a simple process? What costs would be involved? And the answer is yes, it's very simple. It's just doing a new deed, which sets everything up accordingly. It's executing that deed with 2 witnesses and a notary. And then because it's a deed, it has to be recorded in the county property records, which wherever county you're in. None of this is a very big deal, and we guide you through every step. When we do the ladybird deed under the legal plan, it's done for a little cost of $100 total charge. So that's all. The next question is about setting aside money and taking care of pets. We answered that. What is the cost of a basic living trust through Preferred Legal? Very good question. So if you decide that you want to do the trust package as opposed to the ladybird deed and beneficiary setup, we do the trust package, which is the trust, the pour over will, the power of attorney, the healthcare surrogate, the living will, the quitclaim deed to put your property into the trust, and all the other retitling, everything, the whole kit and caboodle, as we like to say. And we do that for a total cost of $300 total charge under the legal plan. And just FYI, if anybody's gone on the street to an attorney, the trust package is more in the range of $2,500. So it is a tremendous savings in that regard. Anonymous asks, are any family members covered with my legal plan benefit, i.e. adult children? Does it make any difference if they want a will that names me as the guardian of my grandchildren? The answer is yes, we cover your dependent children or if they still live with you. But part of the plan of what we're doing now is we'll help any of your loved ones with estate planning. So yes, we can help you to help your adult children get their estate plan in order. And of course, you can be the guardian, or whomever else. What happens if my child, God forbid, passes before they receive their full amount? Good question. So this is back to that trust for children wills that I was mentioning earlier, where the kids get it at 25, 30, 35. What if, God forbid, your kid passes at 32? So there's still that last third is in there. It specifies in your will, where we created this whole trust stuff, that upon the child's death, if there's any more money in there, it will go to that child's children, which would be like your grands. Or if there are none, it will go back to the other children that you have. And if they have a trust, it'll go into their trust to continue like that. And regardless if there is no other child or this or that, if there's nobody named, it reverts back to your state law. And the state law in Florida always provides that it goes down the bloodline. So it's always going to stay on your bloodline no matter what. But that's how that would be handled. It's already kind of addressed in the document. Anonymous asks, how does debt affect what happens with your assets when you have a will? Great question. So if you have a will and nothing else, that means there's going to be a probate after you're gone. One of the things about probate is creditors have a chance to come in and make claims and get paid. If you avoid probate, you avoid the creditors. One of the biggest reasons we love avoiding probate. And that means literally, if you avoid probate, you don't pay 1 penny of the deceased's creditors because they're not entitled to anything. And even though they'll still call you and badger you as the collectors can, but legally, no probate, no creditors. They're left out in the cold. Patty asks, after retirement, is preferred legal services still available? Would it come out of a retirement paycheck? So the answer there is yes, we are fully portable as a benefit. If you ever leave the university, you could take us with you, but usually we would port it, meaning we would set it up with you through your credit card or bank account for the monthly payment, but it's guaranteed at the same rate, same plan, same everything. It would just be through your credit card or bank account instead of your paycheck. But yes, you could always keep the plan. Stephanie asks, I've had a Rev Trust for 15 years, God bless. Can I switch to a Ladybird deed? Absolutely, you can. And for the reasons I stated earlier, the Ladybird deed is even a couple of steps easier than the trust. One of my favorite things to do, take people out of their gigantic trusts and put them into Ladybirds and simplify everything. So absolutely take advantage of that. Anonymous asks, what are some general things to consider for newlyweds? First of all, congratulations. Second of all, not necessarily, well, the triggers we like to say for doing your will or starting your estate plan are you get married. So there you go. You have a child or you buy a piece of real estate. Those are your triggers. If you're single, renting with no children, you don't really need a will right now, probably. But yes, those would be the triggers. So if you get married, it's not a bad idea to start down that path of looking at wills and thinking about those things. Scott asks, it looks like there's some updates to the plan coming in 2026. Does my parent need to live with me for the will prep in 2026? And would this include a step parent? So yeah, we've added some enhancements to our plan for the new year, which we're excited about. And one of those enhancements is that we're helping with estate planning for extended family members. So they don't have to live with you. They could be a step parent. We don't split hairs on this stuff because we look at it like, if we don't help you, it's going to be your problem someday. So we want to help you with it. So yeah, don't hesitate to call on all those relatives and we'll get everybody squared away accordingly. Rachel asks, how detailed do I need to be on the living will document? Do I provide examples of conditions or is it just assigning someone? So the answer is you don't have to worry about that, Rachel, because that form has updated recently where you don't have to check the box and all that stuff on the old form. It's all spelled out. And it basically says that if you're in that very specific circumstance that you don't want to be kept alive artificially, but it's still up to your surrogate to carry it out. So that's the good thing. The doctors aren't going to be like, oh, they got a living will, let's go home for the weekend. They still go to your surrogate to say, should we do this? Should we do that? What do you want us to do? So that's how that will work. Gurjit asks, is there a charge for making wills and trusts? So under the legal plan, the simple will is free. And then the trust package, the complex will package is when a little bit of cost is involved, as I mentioned earlier. I'm going to try to rip through these here since we're getting towards the end. Lucy asks, can I include a clause in my will stating that if I pass away before my child reaches adulthood, any inheritance he receives should first be used to pay off the mortgage on our home before he gains full access to the remaining funds? Yes, yes, yes. Again, you can say whatever you want, as specific as you want. And that's a great, point to make about paying off the mortgage and stuff. Okay, Anonymous asks, how does designated guardian work in a will if there's a surviving parent, but the surviving parent is an ex? Great question. The answer is the ex would likely be named the guardian unless there's some extenuating circumstances why they shouldn't. And if there is, we're going to put that in your will as to your intention as to why the ex should not be named guardian. And then the court, when they read that, will make the ex answer to some of that. if the ex is violent, been arrested, on drugs, alcohol, anything. So that's how that works. Someone asks about notary services. Can you explain more about the online notary services? This is another aspect that we've added to the plan where you have access to us for online notary. All that is just calling to make an appointment with the online notary. And then you have like a Zoom call like this, where the online notary sees you physically sign and then does the notary thing and it's done. Very easy and convenient. Anonymous asks, I'm going to be moving onto my parents' property with them in the next year or so. It's paid off. Is it better to add me to the deed now or just do the ladybird? Again, for tax purposes, ladybird could be a big tax savings there. Can a private mortgage holder tell you who can be on your deed? Ours would not let us add our son at time of purchase. Can we rewrite it to add the ladybird deed without contacting the mortgage holder? Yes. Because it's a private mortgage, though, I would want to look at your paperwork is all. But again, one doesn't have to do with the other, so it should not be an issue. Anonymous asks, my spouse and I have completely separate finances, but if we wish to put our house and all accounts into a trust, does that mean they'll be seen as communal property? Maybe is the answer. But what I would suggest there is doing separate trusts, one for each of you. And you each put your own assets into your own trust. You don't have to do a joint revocable trust. In fact, there's reasons why we don't like a joint revocable trust. So that's how we would do that. Information being sold, I'd like to prevent my public info from being available. John asks, for instance, I'd like to keep my personal name from being seen on my property tax title. Would this be a reason to create a trust with a name that isn't tied to me? Yes, John, that's exactly why people do those types of trusts with a different name, because your real estate stuff is public record. You can also ask your county if they have anything in place to hide your identity like that. Some of them do. Can you do a ladybird deed with stipulations? My nephew lives with me. I don't want him kicked out if I die. Can I leave the home to someone else in the ladybird, but say that my nephew can stay? Yes. Yes. It would be done with the ladybird and then mentioning in your will these other wishes. Wayne asks, to manage assets other than real estate, a trust would be needed? No, because remember, you can beneficiary everything accordingly. And that's an alternative to having to put it into your trust. Victoria says, you had previously mentioned that your parents don't have to live with you for you to help with planning, but do they have to live in Florida? The answer is yeah, because we're Florida lawyers, although don't hesitate to call if we have, can help in another state. If it's a state that has ladybird or this or that, we can help. We can also make referrals to attorneys in other states. We have access to a national network anytime we need. So you could still call on that and we'll figure it out accordingly. Anonymous asks, how are federal taxes handled when a beneficiary cashes out an account, like a CD or a savings account? Any asset received by inheritance is tax-free, unless it's like a pre-tax, like a 401k or something, and then whenever you take the money out, it's going to be taxed, regardless of who it is. But life insurance, regular bank account, tax-free. Does a ladybird deed affect homestead exemption is our last question, and we made it. And the answer is no, you do not lose your homestead just because you do a ladybird. No big deal, no big deal. Constance asks one more question. Do you help people with legal issues besides wills and this type stuff? Great transition for us into our legal plan benefit. Let me spend 1 minute on it. The legal plan benefit, we've been providing it at UF for the past 15 years. It is fully comprehensive. We can help you through the legal plan with any type of legal situation, anything, except as long as it's not anything against the university. No job stuff, no stuff involving the university, but literally anything else you can think of: divorce, child support, custody, real estate, credit repair, landlord-tenant issue, condo association, homeowner association, bankruptcy, immigration, car accident, personal injury, criminal stuff, you name it. We can help you with it. And most important is our our legal plan benefit at UF is one of your UFSelect benefits. And Patricia, correct me if I'm wrong, but this is to be found through your My Self-Service portal, where you find your UFSelect benefits, and then you click it, and then it will come into play for 1/1. One last question here from Susan. She works at UF but lives in Pennsylvania. Can she still use the legal plan? The answer is yes. We have many out-of-state members of our plan, especially since COVID with a lot of remote working. So again, we'll help you, same interface with us, and we tap into a national attorney network when needed. So we've got you there. One last thing, Patricia, which is I wanted to say, I am going to personally be at your benefits fair next Tuesday, the big benefits fair at the Touchdown Terrace at Ben Hill. I will be personally at my table for the legal plan. So please stop by, fist bump, give me a hug, say hello, whatever you like. And we can answer any more questions there, and it'll be lovely to see you.
Thank you so much, Brian. I dropped the links to the benefits fair, the PDF to Preferred Legal, as well as the information of where that video will be housed once the recording is live. It should be about a week or so before we can get the recording up on the website, but we will get it up on the Work Life website. Thank you so much, Brian. And as I said, the Benefits and Wellness Fair is coming up next week on October 14th, I believe. Yes, next week, October 14th. The information of that is on the chat. So be sure to stop by the Preferred Legal table if you want to talk to Brian about the plan as well. Before we sign off, anything else you would like to add, Brian?
No, again, just look forward to see everyone at the fair and take advantage of the legal plan, and it's a great benefit.
Well, thank you, Brian, and thank you, Elizabeth. We appreciate your information and your time.
Pleasure.
Thank you all. Have a good day. Bye.
Thank you, everyone. Have a
Bye.
good one.